and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. A warm welcome to each and every one of you. If you're here, you know that I've covered the Darlie Routier trial transcripts from the very beginning. This is the mother who in 1997 was accused and convicted of murdering her two children in Rowlett, Texas. If you are brand new here and you want to start from the very beginning, you'll find all of the trial transcripts in their very own playlist on YouTube. Now, at this point in time, we have been through all of the trial transcripts, the appeal, and we are now on the second portion of the Writ of Habeas Corpus, and this is the second and final portion. And I look forward to getting back to weekly true crime cases, and I've currently had to push the date back a little bit on those. So instead of the 24th of September, I've got somewhere around October 1st. I'm hoping it'll be sooner than that, but we'll just have to wait and see how long this whole thing takes, right? So before we begin, I want to let you know that within this particular episode, throughout the writ, and I did this a little bit in the part 1, but in this part 2, there's quite a few more references to the affidavits. And I've included those within the writ where it's brought up or where they mention, hey, look at, the affidavit of Darin Routier, for example. At the very end, I have added all of the affidavits that did not make it directly into the Writ of Habeas Corpus part 2 or even part 1. Now, if you don't want to listen to the entire thing or the entire writ, the one thing that I would suggest that you do, because it's incredibly eye-opening, is at least go through each of the different affidavits and what these people had to say, because I think you will be incredibly surprised at what some people had to mention, some things that happened that we never learned about within the trial, and so forth. And what I've done is each one of these are bookmarked. So if you're watching on YouTube or listening elsewhere, within the show notes or the description, if you're on YouTube, you will see the timestamps of each of the different affidavits that I have included in this particular episode. So I'm not going to speak very much longer because this is a very long episode. With that said, let's go ahead and continue with the second part and the final part of the Writ of Habeas Corpus for Darlie. 5. Claims for relief. A. Darlie Routier was denied her Sixth Amendment right to effective assistance of counsel. Trial counsel was constitutionally deficient in two respects. 1. Representation was hampered by an unwaivable conflict of interest between Miss Routier and the only other adult in the house at the time of the murders, her husband. And 2, trial counsel utterly failed to investigate or rebut the purported quote-unquote staging evidence that lay at the core of the state's cause. 1. Trial counsel's divided loyalties between Darlie Routier and her husband constituted ineffective assistance of counsel. A. Relevant facts. Douglas Parks and Wayne Huff were the first attorneys appointed to represent Darlie Routier. Parks considered Miss Routier's husband, Darin, a suspect and planned to introduce evidence against him at trial to create reasonable doubt about Miss Routier's guilt. And here the document references the affidavit of Douglas Parks. So we will hear this next. Next, we have the affidavit of Douglas Parks. And remember, he was one of Darlie's original attorneys assigned to her before Mulder took over. And here is what Mr. Parks had to say. On June 28, 1996, I was appointed counsel for the defendant Darlie Lynn Routier in the case of Texas versus Routier, in which Miss Routier was alleged to have caused the death of her son, Damon Routier. I continued to serve in that capacity until the substitution of counsel on October 21st, 1996. It is my professional opinion, and was at the time that I represented Miss Routier, that a zealous defense of Miss Routier necessarily involves implicating her husband, Darin Eugene Routier, in the death of Damon. At the time I represented Miss Routier, I fully intended to introduce evidence that would implicate Darin Routier at trial, such as, for example, a pair of Mr. Routier's undergarments stained with blood on the elastic waistband. On October 21st, 1995, attorney Douglas Mulder was substituted as counsel for Miss Routier. 1 month earlier, on September 20th, 1996, Mr. Mulder had represented Darin Routier in a contempt of court hearing involving the possible violation of a court order restricting publicity. I had learned that Douglas Mulder was considering whether to accept employment as counsel for Darlie Routier several weeks before October 21st, 1996. Upon learning of this possible employment by Darlie Routier and Mr. Mulder's representation of Darin Routier, I became concerned that Mr. Mulder would be unable to represent both Darlie and Darin Routier without breaching his duty of loyalty to one or both clients. I communicated my concern orally to Mr. Mulder several weeks before his employment on October 21st, 1996. I explained to Mr. Mulder that Darin Routier was a viable suspect in the murder of Damon and that Darlie Routier had not waived any conflict of interest between herself and her husband. Mr. Mulder indicated that he did not believe that Darin was involved in Damon's death, despite the fact that Mr. Mulder had not, at that time, had an opportunity to review the results of defense counsel's investigation. I reiterated my concern to Mr. Mulder in writing on October 24th, 1996, after the motion of substitution of counsel had been granted. I explained to Mr. Mulder that I continued to believe that Darin Routier was a possible perpetrator of the offense, and the court had not addressed the possible conflict of interest generated by simultaneous representation of Darlie and Darin Routier. I sent the letter in part because Mr. Mulder had suggested in chambers of the trial court on October 21st, 1996, that he was not yet fully familiar with all aspects of the case at that time. And this is signed Douglas Parks. Douglas Mulder represented Ms. Routier's husband and her mother, Darlie Kee, during a show cause hearing on September 20th, 1996, where the state alleged that they had violated a gag order regarding Ms. Routier's upcoming trial. In a conversation with Darlie Kee and Darin Routier, Mulder informed them that Parks intended to implicate Darin in the crime as part of petitioner's defense. And here they again reference Darin's affidavit and Darlie Kee's affidavit, and we heard these in part 1, but just to refresh your memory, I'll go ahead and put them in this one as well. First is Darin's, and then we'll move on to Darlie Kee's. And this affidavit was done on July 11th of 2002. And here's what his says. In 1994, I spoke to a person about my Jaguar automobile. In that conversation, I said that, quote, it wouldn't bother me, unquote, if the Jaguar was stolen. The person then stole the Jaguar. In March or April 1996, I asked my father-in-law, Robbie Kee, if he knew anyone who would agree to burglarize my home as part of an insurance scam. I said that I would arrange for my family to be absent from my house at 5801 Eagle Drive, that someone who I would hire would come to the house and take away the furniture and other items from my house in a U-Haul truck, and that I would then pay that person from the proceeds of the resulting insurance payments. Between March 1996 and May 1996, I told multiple people of my planned insurance scam. In the late evening on June 5th, 1996, I had a verbal disagreement with my wife, Darlie Routier. During that discussion, my wife asked me for a marital separation. I first met with attorney Douglas Mulder in July 1996. I met at least once a week with Mr. Mulder in July 1996. The subject of the meetings was Mr. Mulder's potential representation of my wife, Darlie Routier, and I in her criminal trial. I continued to meet with Mr. Mulder in August 1996. During one of the meetings I had with Mr. Mulder in August 1996, he told me that the court-appointed attorneys in my wife's case, Wayne Huff and Douglas Parks, had confided in him that they were going to try and portray me as the person guilty of the murder of my sons Damon and Devin, because they thought that I had something to do with the deaths of my sons. I told Mr. Mulder that if we hired him, I did not want him to quote unquote go after me. Mr. Mulder agreed that if hired to represent my wife, he would not argue as part of the defense that I was in any way responsible for the death of my children. Between July 1996 and late September 1996, I continued to meet regularly with Mr. Mulder. On September 30th, 1996, Mr. Mulder represented me at a show cause hearing before Judge Toll, where the state of Texas alleged that I violated a gag order in the criminal case against me to my wife. It's September and October 1996, I believe, based on Mr. Mulder's comments to me, that he was my attorney. On October 21st, 1996, Mr. Mulder became lead counsel in my wife's criminal trial." Unquote. Next, we'll hear Darlie Kee's affidavit. It was created on July 12th of 2002. Quote, "My name is Darlie Kee. I am over the age of 21 years old and I reside in Wills Point, Texas. I have never been convicted of a crime, and I am capable and fully competent to make this affidavit. I have personal knowledge of the facts stated in this affidavit, and those facts are all true and correct. I am the mother of Darlie Lynn Routier, who was accused of by the state of Texas in the capital case of Texas versus Routier. July of 1996, my son-in-law, Darin Routier, and I searched for counsel to represent my daughter in her capital trial. Over the course of my search, various individuals suggested that we retain attorney Douglas Mulder. Darin and I first met Mr. Mulder in July 1996, and we met with him again many times in August of that year. During one of our August meetings, Mr. Mulder told Darin and me that Douglas Parks and Wayne Huff, the court-appointed attorneys for my daughter, intended to blame Darin for the murder of my grandson, Damon. Darin then told Doug Mulder that one of the reasons we were going to retain him was because Doug was not buying into the theory that Darin was involved in this crime. Mr. Mulder assured us that if he was in charge of the case, he would not do that. We decided to hire Mr. Mulder, and he became my daughter's lawyer on October 21st, 1996. We eventually paid him about $95,000. When Darin and Darlie Kee learned of Parks' strategy, they sought to replace him with counsel who would not accuse Darin. Mulder, quote, agreed that, if hired to represent Darlie, he would not argue as part of the defense that Darin Routier was in any way responsible for the death of his children, unquote. As a result of this promise, Darin and Kee asked Mulder to represent Ms. Routier at trial. On October 21st, 1996, Douglas Mulder became counsel of record for Ms. Routier, replacing her court-appointed attorney, Douglas Parks. Even without knowing about Mulder's agreement to suspend any investigation of Darin, both Parks and counsel for the state believed Mulder to be incapable of representing Ms. Routier because of a conflict of interest. In an October 24th, 1996 letter to Mulder, Parks stated that, quote, he continued to believe that Darin Routier was a possible perpetrator of the offense, unquote. In the same letter, Parks further advised Mulder, quote, that the court had not addressed the possible conflict of interest generated by simultaneous representation of Darlie and Darin Routier, unquote. Parks' concerns were more than just mere conjecture. On November 12, 1996, the state filed a notice of possible conflict of interest with the trial court, alleging that Mulder's previous representation of Darin created a conflict of interest that jeopardized Ms. Routier's Sixth Amendment right to conflict-free counsel. The state filed the notice to, quote, make real sure, unquote, that there was no constitutional violation since the state had found, quote, some new evidence, unquote, implicating Ms. Routier's husband. That notice stated, in relevant part, that the, quote, investigation was ongoing with regards to the analysis of physical evidence, and recent analysis of physical evidence suggests that Darin Routier may have participated in the crime, unquote. When the trial court addressed Ms. Routier in open court on November 12th and November 18th, 1996, about the state's notice, Mulder did not state on the record his opinion about whether a conflict existed. In addition to these warnings, Mulder was aware of several significant pieces of evidence implicating Darin Routier in the crime, including 1. His hair on the murder weapon. 2. The bloody sock found in the alley contained fibers from his bloody sneakers. 3. Inconsistent statements about his bloody jeans. 4. Blood on his jockey shorts. And 5. His inconsistent statements and suspicious behavior at the crime scene and hospital. Mulder failed to even investigate these leads. Ignoring the evidence available to him and warnings of a conflict of interest, Mulder kept true to his word. The only evidence that he introduced implicating Darin was not offered until the punishment phase of Ms. Routier's trial, when the information could no longer be used to harm Miss Routier's husband because she had been convicted. And then here in this document, they have the word compare, and then they have some document numbers. And this is what it goes on to say. Mulder's non-adversarial questioning of Darin during the guilt phase of the trial, so compare that with what he said later, which was, quote, "You know, it's curious to me, and I have never for a minute doubted the innocence of Darin Routier. But you know, he of all people had the most to gain here. She had a couple of $100,000 worth of insurance on her," unquote. If Mulder had not been burdened by a conflict of interest, he would have learned that in the spring of 1996, Darin Routier was contemplating an insurance scam that involved staging a burglary of his residence. And here they mentioned the Robbie Kee Affidavit, and Robbie Kee being the stepfather of Darlie Lynn Routier. So let's hear what Robbie had to say in his affidavit. Next, we're going to hear from Robbie Kee, Darlie Kee's husband. And although he did not testify at trial, he did provide an affidavit to Darlie's defense team in 2002. And his reads as follows. I am married to Darlie Kee, and my stepdaughter is Darlie Lynn Routier. In approximately earlier spring of 1996, Darin Routier was at my home, and we were in the kitchen when he asked me whether I knew of anybody who would burglarize his home so he could make an insurance claim. Darin Routier explained that he and his family would be gone from the house and that the quote-unquote burglar would come to the house with a U-Haul truck and remove quote-unquote gobs of stuff from the house and take the items somewhere. Darin Routier said he would retrieve the items after his insurance company paid off and that he would pay the quote-unquote burglar out of the insurance proceeds. And we continue with the writ. Darin Routier asked his wife's stepfather whether he, quote, knew of anyone who would agree to burglarize his home as part of an insurance scam, unquote. Darin Routier explained that he and his family would be gone from the house and that the burglar would come to the house with a U-Haul truck and remove, quote, gobs, unquote, of stuff from the house, which he would retrieve, quote, after his insurance company paid off, unquote. Darin Routier has admitted that he had this conversation with Robbie Kee only days before the attack on his wife and children. And here they mention the affidavit of Richard Reyna. Next up is the affidavit of Richard Reyna, and his affidavit goes like this. In the course of investigating the capital murder conviction of Darlie Lynn Routier, I have personally interviewed with Darin Routier, husband of Darlie Lynn Routier. During the month of March 2001, I was informed by Darlie Kee, mother of Darlie Lynn Routier, that her husband, Bob Kee, told her that he had a conversation with Darin Routier. Mr. Routier told him that prior to the death of his two children and the attack on his wife, he had been thinking about having the house burglarized for insurance purposes. Bob Kee said that Darin Routier used the slang word hit instead of burglary. A few days after receiving this information, I met with Darin Routier near Rowlett, Texas. Mr. Routier at first denied that he ever told Bob Kee that he was thinking about having the house burglarized for insurance purposes. He then admitted that he did tell Mr. Kee, but that he did not follow through. On May 8, 2002, at approximately 9 a.m., I met with Darin Routier at the Weather Vane restaurant in Buffalo, Texas. Mr. Routier admitted again that a few days before the murder of his two children and attack on his wife, he did tell Bob Kee that he was thinking about having the house burglarized. And it's signed Richard Reyna. And we continue with the writ. Nor was this an isolated instance of Darin's willingness to engage in an insurance scam. 2 years prior to the murders of his two children, Darin Routier arranged to have his Jaguar, quote-unquote, stolen so that he could collect the insurance proceeds. That quote-unquote crime went without a hitch. Darin's intent to stage a burglary at his house could have explained several items of evidence that the prosecution could not explain in its case in chief. First, there was the issue of a mysterious black car that numerous witnesses testified they saw in the neighborhood around the time of the attacks at the Routier's home. And then they note to see the testimony of Barbara Dovell, which says, question, well, It was the earlier day she was working, whatever day that was. Answer, right. But she saw, yes, she did see a black car in a back alley. And when he passed us by really fast or a black car passed us by, she said she saw the black car in the back alley when she was in the garage. He was like sitting and like waiting for somebody, but he was looking into the garage. Question, like he was watching the house? That's what your mother told you, wasn't it? Answer, something like that, yes. And then the testimony of Karen Neal. Quote, answer, I came home from work about 3 o'clock in the afternoon, and I saw a small black car that was stationed right in front of my sidewalk. Question, okay, and how was that small black car parked in that area? Answer, it was against my curb, and the person in the car seemed to be angled towards the Routier home. Question, all right, and you told the jury that he appeared to be focusing on the Routier house? Answer, yes, sir. Question, okay. Did that strike you as unusual? Did you say anything to him or do anything or go in the house or? Answer, when I got out of my car to approach him, he sped off very fastly, unquote. Second, there was testimony regarding 2 suspicious men, one of whom fit Darlie's description of her assailant, walking along a stretch of Darlie Road, approximately a 10-minute walk from the Routier's home, sometime, quote, after 2 o'clock a.m. on June 6, 1996, unquote. And here they reference the affidavit of Darlene Potter, so let's hear what she had to say. On June 5th, 1996, I had been in Claiborne, Texas until late at night visiting my daughter. I then returned to my residence and was traveling on Dalrock Road in Rowlett, Texas, after 2 o'clock a.m. on June 6th, 1996. On Dalrock Road, north of Highway 66, I was driving northbound approaching the S curve. My vehicle was a full-size van, and I was pulling a trailer. As I approached the first part of the S curve, I put on my brake lights and slowed way down because of the trailer. I suddenly saw a man walking on the edge of the left side of the roadway, headed in the same direction I was going. He was about 6 feet tall, medium build. He had shoulder-length brownish hair, which was messed up, wearing a black t-shirt. He was barefooted. I was surprised that anybody was out in this area at that time, and I particularly noted that he was barefooted. I looked closely at him as I drove slowly past him and continued to look at him in my side mirror as I came out of the curve. When I looked ahead again, I saw a second man walking on the left edge of the road. As I approached this man, he stepped from the side of the road as if he were walking toward my vehicle. I was just starting to accelerate slowly from out of the curve at this time when I saw the man stepping towards my car. He looked in the direction of the first man. I then looked in my mirror again and saw the first man shaking his head as if to say no to the second man. The second man had a light-colored baseball cap on, white shirt, blue jeans. He didn't have any facial hair. He was about 5'8", tall and stocky. Both men were white and appeared to be between 22 and 28 years old. I was worried about who these men were and wondered why they were out on foot at this time of night. I lived near this area where people are known to walk through the adjoining property occasionally, and I was also worried about these guys coming near my house. I went to bed but couldn't sleep, and about 45 minutes later, I noticed a small, dark-colored car driving through the field next door. It appeared to be riding its brakes. I would estimate that it is no more than a 10-minute walk from the home of Darlie Routier on Eagle Drive and the S-curve on Dalrock where I first saw the men. And again, this is signed Darlene Potter, and this was in July of 2002. They then continue with the writ. B. Legal basis for the claim. When a defense attorney actively represents conflicting interests, the prejudice prong of the Strickland test is presumed. The term conflict of interest means, quote, a division of loyalties that affected counsel's performance, unquote. Quote, a conflict of interest has detrimental effects on representation because of what it tends to prevent an attorney from doing, unquote. And then they cite another court case, Rubin versus G, which says finding that trial counsel's conflict of interest constituted ineffective assistance of counsel. And then they cite Holloway versus Arkansas, and also Sanders versus Rattel, which goes on to say, quote, "The harm may not consist solely of what counsel does, but of what the advocate finds himself compelled to refrain from doing, not only at trial, but also during pre-trial proceedings and preparations," unquote. In this case, defense counsel Mulder had divided loyalties to Darlie Routier and Darin Routier. As a result, his assistance to Darlie Routier was ineffective. Mulder suffered from two distinct conflicts. One, he represented Darin Routier in a matter substantially related to this case, and two, he agreed not to pursue an obvious defense strategy as a precondition to his representation. Each separately provides more than sufficient basis for a finding of ineffective assistance of counsel. C. This error is not harmless. The error is plainly not harmless. If Mulder had investigated Miss Routier's husband, the insurance scam would have been uncovered and presented to the jury. This would have been more than sufficient to establish reasonable doubt as to the identity of the killer and undermines confidence in the jury's verdict. 2. Defense counsel's failure to investigate and rebut physical evidence that lay at the center of the state's case constituted ineffective assistance of counsel. A. Relevant facts. Miss Routier's court-appointed counsel, Douglas Parks and Wayne Huff, retained two forensic scientists, Terry Labor and Barton Epstein, to consult with the defense on physical evidence. Labor and Epstein had been given access to a variety of crime scene evidence, including Miss Routier's nightshirt, photographs of the blood spatter in the garage and utility room, the garage window screen, and the bread knife from which a fiber was recovered. Labor and Epstein's preliminary finding was that the evidence was consistent with Darlie Routier's testimony that she and her sons had been attacked by an intruder, thereby contradicting the state's theory that Routier had quote-unquote staged a crime scene. Labor and Epstein recommended the testing of key physical evidence, including the 1. bread knife, 2. Miss Routier's nightshirt, 3. Hoover vacuum cleaner, 4. carpeting, and this has to be a typo, but it also says 4. Darin Routier's jeans, and 5. pillow and furniture. Labor believed not merely that such testing was possible, but that it was necessary. And here's what he said. In my professional opinion, a scientific testing of the physical evidence would have been critical to Miss Routier's defense. Independent testing of that physical evidence was crucial to properly evaluate the state's case. There were numerous potential holes in the state's case that required testing to conform or refute the state's presentation of the evidence and to provide evidence that could well have refuted the state's forensic testimony. These and other tests would have been critical to developing the physical evidence to refute the state's use of forensic and physical evidence and establish Miss Routier's innocence. In October of 1996, when Douglas Mulder replaced Parks and Huff, Mulder and his investigator had a perfunctory meeting with Labor to discuss the scientific analysis he and Epstein had conducted to date. During the meeting, Labor provided a general overview of their work. Mulder and his investigator asked virtually no questions about the work and generally were uninterested in Labor's analysis. In total, the meeting lasted about 2 hours. Labor expected that Mulder or someone from his defense team would follow up with him because, quote, the time in the introductory meeting was not sufficient time to explain in necessary depth the forensic significance of the analysis Barton, Epstein, and I had performed or had recommended be performed. Labor did not hear from Mulder again, however. At trial, the state presented the testimony of a number of expert witnesses who claimed that the crime scene had been quote-unquote staged by Miss Routier. Charles Linch, an expert from the Southwestern Institute of Forensic Scientists, also known as SWIFS, provided key testimony that microscopic debris recovered from a bread knife found in the kitchen at the Routier's residence was quote-unquote consistent with material from the garage window screen and, therefore, likely was the instrument used to create the quote T-shaped defect in it, unquote. Miss Routier had testified that the intruder exited the house through that torn window screen. Lynch testified. Question. Bottom line, from this comparison of the black rubbery material and the glass rods on the window screen and on this knife, what does that say to you as a trace evidence analyst? Answer. I couldn't tell the difference between this debris and the debris found on the knife, and, therefore, the knife could have been used to cause the cut. Defect. Question. Okay. It's certainly, are you saying that the material that you found on this knife blade is consistent with the material that makes up this screen right here? Answer. That's right. Question. You couldn't see any difference? Answer. That's right. The state confirmed the significance of this testimony during its closing argument. Quote, when Lynch tested cutting that bread knife, he looked at it under the microscope, and what did he find? Glass rods, the same type of rubber material seen on the bread knife, and that same type of rubber debris with the glass meshed in, the same type of stuff that happens when you cut the screen. And it adds up that the bread knife was used to cut that screen, and Charles Linch found the evidence. And that tells you they were trying to fake the crime scene. You aren't going to have an intruder somehow get in the house and then take the knife out and then cut the window, unquote. Tom Bevel, the state's blood expert, said he conducted several experiments to determine the type of pattern a bloody knife would leave if it had been dropped by the intruder when exiting through the garage. When asked to compare a photograph of the patterns created in his experiments with photographs of the crime scene, Bevel testified. Question. Now, looking at state's exhibits 38A through 38D, Mr. Bevel, do you see any bloodstain pattern in any of these 4 photographs that correspond to the types of blood patterns that you saw during your test on November 26, 1996? Answer, no, sir. Question. The blood drops that we see in 38A through 38D, are they consistent or inconsistent with a bloody knife being dropped or thrown onto the utility room floor on June 6, 1996? Answer, they would be inconsistent. Again, the state confirmed the significance of Bevel's testimony during its closing argument. After reminding the jury that, quote, defendant's testimony is that this man ran off with a knife and dropped it in the utility room, unquote, the state argued that Bevel's experiments demonstrated that, quote, when you drop that knife, it leaves a mark. It leaves cast off. And you don't see any cast off or any mark left in that utility room. That lets you know that Miss Routier is lying about that, unquote. Bevel offered additional significant testimony about experiments that he had conducted to determine the type of blood patterns that would be created on the clothing of the attacker. He stated, quote, taking a knife that was the same diameter of the knife in question, I just simply, in this case, I went down to my knee after placing a clean t-shirt on my body, put blood on the knife on both sides, again, held it up, and allowed it to just simply stop its dripping. And then just simply did a motion such as this. I think on the first time I did it with 2 swings, if you would, without adding any additional blood to see if in fact we get the blood that would be on the back that would be consistent in size, direction, location as the blood in question on the t-shirt worn by Miss Routier on the morning of the attack, unquote. When asked to explain the significance of his findings, Bevel continued, quote, I was able multiple times to get bloodstains that were the same size, location, with the long axis up and down in that area and on other areas of the back of the test shirt, unquote. During its closing argument, the state predictably told the jury that these experiments, quote, tell you that she was stabbing and Devon's blood winds up on her back. It's not going to wind up there as she is laying on the couch as the man wrestles at her neck, unquote. The state's witnesses also testified that unidentified fingerprints found on the crime scene belonged to Miss Routier or the children. For example, retired Rowlett police officer James Cron misleadingly told the jury that a bloody fingerprint on a table leading from the living to the kitchen lacked, quote, sufficient points of identification, unquote, to identify, but was, quote, consistent with having been left by a 5 or 6-year-old child, unquote. Specifically, Cron testified, answer, that there is ridge detail, a few points of comparison, but I couldn't make any identification. Question, okay, same thing as you had with the other sets that I have just shown you? Answer, yes. These are better prints, but still lacked sufficient points of identification. The state then invited the witness to speculate as to the source of the latent prints. Question. Okay. How would you classify the size of these two latents? Answer. Small. Question. Okay. What do you mean by small? What would that be consistent with? Answer. A juvenile. It could be. It fits the criteria to be a younger person's prints. Question. Okay. What are those criteria? Answer. Small ridges. Question. Let me just ask you, the two prints here, 85I and J, would they be consistent with having been left by a 5 or 6-year-old child? Answer. It is possible. Yes, sir. Trial counsel, having fired the forensic experts, presented no evidence to contradict any of the state's staging evidence. This fact was not lost on the state or the jury. During its closing argument, the state highlighted to the jury that defense counsel presented no contrary scientific evidence because he had none. Quote, "We know that back in August of last year that there was an expert by the name of Bart Epstein, a trace evidence analyst there at Swift's on behalf of the defendant. And we know that back there in August that Charlie Linch said, 'Here, I will show you everything that I am doing out here.' He let him look at the slides, let him examine the evidence. Basically, he looked over Charles Lynch's shoulder and graded his work out there at Swift's. And don't you know that if Bart Epstein had any disagreement whatsoever with the findings of Charlie Linch, that you would have seen him appear on this witness stand. You know, here is the bottom line on Tom Bevel. You know out there at Swift's, there is another expert, Terry Labor. He is the DNA blood spatter expert who went out there on behalf of the defendant also, along with Bart Epstein. And if they want to quarrel with Tom Bevel and tell you that he is wrong and that he is a witch doctor of some sort, where is Terry Labor then? Where is their blood spatter expert? Don't you know that if he had any criticism of the opinions rendered by Tom Bevel, that just like Bart Epstein, you would see them right up here, and he would be detailing for you what those criticisms are. But he is not here either, is he? And for a very good reason. There is one other thing that we need to ask also. Where are the samples from the t-shirt taken by Terry Labor? Where are they? You remember those first dibs samples that Terry Labor took from the defendant's t-shirt back in August, before Tom Bevel even had a chance to look at the t-shirt? Terry Labor, the defendant's expert, went to Dallas and was given an opportunity to take several samples from that t-shirt. Did you see those samples in this courtroom at any point during this trial? No, you didn't. Don't you wonder why? You really don't have to wonder long about that question. It's obvious to you, unquote. Such inflammatory and misleading arguments obviously were intended to and did lead the jury to reject Ms. Routier's intruder testimony. As even the state's expert has acknowledged, quote, "It is my professional opinion that if Bart Epstein and Terry Labor were released from their retention as expert witnesses for Darlie Routier's defense, such release constituted a grave error on the part of Darlie Routier's defense counsel," unquote. Next up, we have the affidavit of Charles Linch. He actually has two affidavits, and this is affidavit number 1. And it's dated July 11th, 2002. It starts off with a lot of his history, his work history, how old he is, and so forth and so on. And at the time that he created this affidavit, he was no longer working with Swifts. And this is what his first affidavit says. On or about June 6th, 1996, during my employment at Swifts, I became involved as a forensic analyst for the state in the murders of Devin and Damon Routier. In addition to collecting certain trace evidence at the crime scene, I was provided with numerous pieces of evidence at the Swifts laboratory. I performed both hair and fiber analysis of the evidence collected from the crime scene. Based on the results of this analysis, I ultimately testified as an expert witness for the state of Texas in the trial of Darlie Routier. On August 23rd, 1996, I was visited at the Swifts laboratory by Darlie Routier's original defense counsel, Douglas Parks and Wayne Huff, as well as the defense's investigator, Cliff Jenkins. On at least 2 occasions prior to that date, I had met with Douglas Parks, Wayne Huff, and/or investigator Jenkins in order to provide them with access to the evidence in the state's custody and discuss my findings regarding that evidence. On August 23, 1996, Douglas Parks, Wayne Huff, and Cliff Jenkins were accompanied by two forensic scientists, Bart Epstein and Terry Labor. It was my understanding that Bart Epstein and Terry Labor had been retained by Douglas Parks and Wayne Huff to conduct a forensic analysis of the physical and trace evidence in my custody. Bart Epstein, Terry Labor, and I met for approximately 3 hours to discuss the evidence in the Routier case. During that meeting, Bart Epstein and Terry Labor reviewed the evidence in my possession, including, but not limited to, A, all microscope slides I had prepared, B, the nightshirt worn by Darlie Routier on the night of the murders, C, the Hoover vacuum cleaner, D, the large maroon pillow, E, pieces of carpet and flooring containing bloodstains and spatters, and F, Darin Routier's blood-stained blue jeans. The microscope slides I prepared contained screen material, hairs, fibers, and glass, including, but not limited to, fiber and opaque material I removed from the knife found on the Routier kitchen counter, and fibers from tests I performed on the garage window screen. During the course of our August 23, 1996 meeting, Bart Epstein and Terry Labor performed a detailed analysis of the evidence I provided. Bart Epstein conducted a microscopic comparison of all of the microscope slides I had prepared. Terry Labor collected samples from some of the larger pieces of evidence, such as Darlie Routier's nightshirt, and took detailed notes regarding the evidence examined. I was not informed of Bart Epstein and Terry Labor's conclusion based on their analysis of the Routier evidence. However, the evidence tested by Bart Epstein and Terry Labor may have enabled them to form conclusions that contradicted or called into question the state's theory of the case. I was not contacted by either Bart Epstein or Terry Labor following our August 23, 1996 meeting at Swift's. I do not know if they conducted further tests on the evidence they collected from me. Bart Epstein and Terry Labor's absence from Darlie Routier's trial team coincided with the appointment of Douglas Mulder and Richard Mosty, who assumed the representation of Darlie Routier from Douglas Parks and Wayne Huff. Following my August 23, 1996 meeting with Bart Epstein and Terry Labor, I was not contacted by any other trace evidence experts for the defense in the Routier case. As a trace evidence analyst, it is my professional opinion that further forensic testing on this evidence would have been appropriate in order to adequately investigate the factual basis of the prosecution's theories. Specifically, it is my professional opinion that if Bart Epstein and Terry Labor were released from their retention as expert witnesses for Darlie Routier's defense, such release constituted a grave error on the part of Darlie Routier's defense counsel. And again, it's signed July 11, 2002 by Charles Linch. As forensic experts, Labor and Epstein had observed, quote, numerous pieces of physical evidence we reviewed that were not consistent with a staged crime scene, unquote. And the state's quote unquote staging evidence could have been rebutted had trial counsel tried to do so. For example, defense experts could have testified that the bloodstains on the back of the nightshirt Miss Routier wore were not quote unquote cast off from a stabbing motion. Experts would have been able to show that the source of fiber on the kitchen knives was debris from the fingerprint, brush, and powder used first to dust the window screen and then the knives found in the kitchen. Next, we have the affidavit of Samuel Palenik. And he says, I received a BS in chemistry with emphasis on analytical methods from the University of Illinois at Chicago in 1974. Since graduating from the University of Illinois at Chicago, I have worked as a research microscopist and eventually a senior research associate at McCrone Associates and a senior research microscopist at Microtrace. I am presently employed as the president and senior research microscopist at Microtrace and have been so employed since 1992. As part of my work as a forensic microscopist, I analyze microscopic physical evidence left at crime scenes to determine its identity and origin and to compare it to suspect sources employing state-of-the-art techniques of microanalysis. I am a member of several forensic science and scientific societies, including the American Academy of Forensic Sciences, Midwestern Association of Criminalists, the Canadian Society of Forensic Sciences, Midwestern Association of Forensic Sciences, and the Royal Microscopical Society in the UK, and the American Chemical Society. I have reviewed testimony from State of Texas versus Darlie Routier related to the fiber that was recovered from knife number 4, the bread knife from the knife block found in the kitchen of 5801 Eagle Drive, Rowlett, Texas. I have also reviewed slides that purport to compare this removed fiber with material from the garage screen window, photographs of the garage window screen, and a sample of window screen similar to the torn screen at 5801 Eagle Drive, Rowlett, Texas. I have not been able to view the actual fiber itself. I understand that the fiber is in the state's custody and that defense counsel has been refused access to it. Based on my review of the testimony, photographs, slides, and sample window screen, it is my opinion that the origin of the fiber removed from knife number 7 can be determined more definitively than has been done previously by a study of the microscopic morphology alone. The optical properties, in particular the refractive index and the elemental composition of the fiber, can be established with certainty using polarized light and/or interference microscopy for the latter and X-ray spectroscopy in the scanning electron microscope for the latter. The composition of what appears to be the elastomeric binder can be established in infrared, microspectrophotometry. To do this, it will be necessary to isolate the materials from the microscope slide, wash them off, and subject them to the appropriate tests. I have also reviewed Charles Lynch's testimony in State of Texas versus Darlie Routier related to 4 defects in the right shoulder area of the Victoria's Secret nightshirt that Darlie Routier was wearing on the night of the events at, and here is a typo, 3801 Eagle Drive. I have not been able to examine that actual nightshirt because I understand that it too is in the state's custody and that defense counsel has been refused access to it. Based on the information I have about the nightshirt, it is my opinion that it may be possible to determine by microscopical examination if the 4 defects were created by the same instrument as the nightshirt defects that correspond to Darlie Routier's injuries. To conduct the above described testing, I would need access to knife number 7, the fiber removed from knife number 4, a sample of the actual torn garage window screen at 5801 Eagle Drive, Rowlett, Texas, knife number 2, the murder weapon, and the Victoria's Secret nightshirt. None of the testing that I propose to do on knife number 4, fiber, and the Victoria's Secret nightshirt would destroy the physical sample. It is my understanding that Charles Linch testified for the state at trial that the fiber recovered from knife number 4 was quote-unquote consistent with the material from the garage window screen. It is my opinion that if knife number 4 was dusted using a brush and fingerprint powder, and if the knives in the same block were also dusted using a brush and fingerprint powder, then it is possible that the fibers in knife number 4 came from the brush used to dust the knives found in the kitchen rather than from the garage window screen. Charles Lynch's second affidavit is actually dated on the same day, July 11th, 2002. And it goes on to give a short introduction about his name and his age, and then says, "This is the second of 2 affidavits I have filed in the above captioned action, based on my capacity as an expert witness for the state of Texas in the capital murder trial of Darlie Routier. The first affidavit, styled First Affidavit of Charles A. Linch, set forth my interactions with Bart Epstein and Terry Labor, the forensic experts initially retained by Darlie Routier's defense counsel." He then goes on to continue giving his background and his where he's worked, his education, and so forth. And then he goes on. He says, "On or about June 6th, 1996, during my employment at Swift's, I became involved as a forensic analyst for the state in the murders of Devin and Damon Routier. In addition to personally collecting certain trace evidence directly from the crime scene at 5801 Eagle Drive, Rowlett, Texas, investigators for the state provided me with numerous pieces of evidence for analysis. This evidence was collected from the crime scene at 5801 Eagle Drive, Rowlett, Texas, and delivered to me at the Swift's laboratory. I performed both hair and fiber analysis of the evidence collected from the crime scene. Based on the results of this analysis, I ultimately testified as an expert witness for the state of Texas in the capital murder trial of Darlie Routier. On or about June 8th, 1996, I received several pieces of evidence from Detective Jim Patterson. This evidence included a butcher block with 8 knives. The butcher block and the knives were identical to the butcher block and knives I observed on the kitchen counter at 5801 Eagle Drive, Rowlett, Texas on June 6, 1996. At the time I received this butcher block and knives at the Swift's laboratory, both the butcher block itself and all the knives in it had been dusted for fingerprints. This included a serrated bread knife, which I later designated as knife number 4. This knife was located on the left end of the bottom row of knives in the butcher block. The serration grooves in knife number 4 contained debris consisting of microscopic rubber dust particles and microscopic fiberglass rod fragment. Based on my forensic microscopic comparison, this material was microscopically consistent with debris obtained from the garage window screen at 5801 Eagle Drive, Rowlett, Texas. However, while I was asked only to perform microscopic tests on these samples, microscopic comparison is not the most discriminating method available to determine the source of this debris. If the rubber dust particles and fiberglass rod fragment can be located and removed from the mounting media for testing, more discriminating chemical testing can be performed on this evidence to determine if the debris found in knife number 4 is in fact consistent with the debris from the window screen material. For example, a Fourier transform infrared microscopy (FTIR) test can be used to create a chemical fingerprint of the microscopic rubber particles. As a trace evidence analyst, I would recommend such testing be conducted if possible. To the best of my personal knowledge and belief, the fiberglass rod fragment obtained from the serration grooves of knife number 4 is located at either A, the Bexar County Forensic Laboratory, San Antonio, Texas, on a SEM planchet, or B, at the Southwestern Institute of Forensic Sciences, Dallas, Texas, on a glass microscope slide. And again, this is dated July 11th, 2002. But defense counsel never pursued this or other available scientific analysis to test Lynch's microscopic examination of the origin of the fiber. Contrary to the state's theory that the vacuum cleaner was pushed around by someone bleeding as part of a staged crime scene, Labor and Epstein had concluded that most of the bleeding had occurred after the vacuum cleaner had been knocked down. Next, we have the affidavit of Terry Labor, and Terry was worked with Darlie's original attorneys. He was one of the investigators assigned to examine the physical evidence in the case. And here is what Terry Labor has to say. He first gives a little bit of his background. He then goes on. In August of 1996, I was retained by Douglas Parks and Wayne Huff, then defense counsel to Darlie Lynn Routier, who was then scheduled to be prosecuted for the death of her son, Damon Routier. As part of that engagement, my colleague, Barton Epstein, and I viewed a number of pieces of physical evidence then in the custody of the state of Texas. In August 1996, Barton Epstein and I met with state's forensic analyst Charles Linch at the Southwestern Institute of Forensic Sciences in Dallas, Texas. We reviewed a number of pieces of physical evidence in Mr. Lynch's possession. We also reviewed evidence in possession of the Rowlett Police Department. Barton Epstein and I recommended to Mr. Parks and Mr. Huff that certain samples of physical evidence that we reviewed be analyzed to test the state's theory that the crime scene at 5801 Eagle Drive, Rowlett, Texas, had been staged. For example, fiber and opaque material said to have been removed from bread knife. We recommended that microscopic and/or elemental comparison tests be conducted on the fiberglass and opaque materials removed from a bread knife to substantiate or dispute the state's theory that the source of these materials was the window screen in the garage of 5801 Eagle Drive. Other fibers said to have been removed from knife on counter. We recommended that the apparent wood fragments and blue fibers removed from the knife found on the kitchen counter be microscopically examined to determine their source. Darlie Routier's nightshirt. Based on the defects, for example, the cuts, observed on the left side of the nightshirt, we determined that additional testing was required to identify the source of the defects. In addition, we recommended that genetic testing be conducted on several blood-stained areas of the nightshirt. Hoover vacuum cleaner. Based on our visual examination of the bloodstains found on the Hoover vacuum cleaner, we determined that genetic testing was required to determine the source of the blood. Carpet. We recommended DNA and possible chemical testing of bloodstains and prints left on the carpet from 5801 Eagle Drive. Darin Routier's blue jeans. We recommended that genetic testing be conducted on several blood-stained areas of Darin Routier's blue jeans. The pillow and furniture. We recommended that genetic testing be conducted on several blood-stained areas on the living room furniture, pillow, and on the wine rack. In late October 1996, Douglas Parks informed Mr. Epstein and I that he had been replaced as defense counsel by Darlie Routier and that we should send him a final bill for our services. Shortly thereafter, Mr. Parks informed us that he had been removed as trial counsel and Douglas Mulder had been substituted as the new trial counsel. In late October or November 1996, I met with Douglas Mulder and his investigator, Lloyd Harrell, to discuss the testing that Barton Epstein and I had conducted to date. Barton Epstein did not attend that meeting. During the meeting, I provided Mr. Mulder and Mr. Harrell with a general overview of the work done to date by Mr. Epstein and I. It was my impression that neither Mr. Mulder nor Mr. Harrell seemed particularly interested in that work. Both men asked me only a few questions. The meeting lasted about 2 hours. Following the meeting, I expected that Doug Mulder or one of his colleagues would follow up with me because the time in the introductory meeting was not sufficient time to explain in necessary depth the forensic significance of the analysis Barton Epstein and I had performed or had recommended be performed. Mr. Mulder did not retain either Barton Epstein or me to perform any of the testing we recommended, and so we discontinued all work on the case. I had no further involvement in the trial of Darlie Lynn Routier after November 1996. Based on the analysis I performed in this case, it was my professional opinion in November 1996, and is my professional opinion today, that there were numerous pieces of physical evidence we reviewed that were not consistent with a staged crime scene. For example, review of the blood spatter on and near the vacuum cleaner indicated that the vacuum cleaner had not been pushed around by someone bleeding, but instead that most of the bleeding had occurred after the vacuum cleaner had been knocked down. The placement of shards of glass below the location of the wine glasses indicated that the wine glass had broken while still in the rack and was not consistent with a person smashing or throwing the glass onto the floor as part of a staged crime scene. In my professional opinion, scientific testing of the physical evidence would have been critical to Darlie Lynn Routier's defense. Independent testing of that physical evidence was crucial to properly evaluate the state's case. There were numerous potential holes in the state's case that required testing to conform or refute the state's presentation of the evidence and to provide evidence that could well have refuted the state's forensics testimony. These and other tests would have been critical to developing the physical evidence to refute the state's use of forensic and physical evidence and establish Darlie Lynn Routier's innocence. Based on my blood spatter analysis experience, for the theory that direct hits of Darlie Lynn Routier's blood being spattered from her stab wound precisely covered each blood spatter of her two sons, Damon and Devin, to have been correct, would have required an extremely unlikely sequence of events. My preliminary analysis of the shirt Darlie Lynn Routier was wearing indicated only minimal area of blood spatter, and the critical areas of spatter were not subjected to genetic testing. Genetic testing should have been conducted on those blood-stained areas of Darlie Lynn Routier's nightshirt. In addition, a microscopic examination should have been performed to determine the source of cuts observed on the left side of the neck of the nightshirt. Testing of the fiberglass and opaque material said removed from the bread knife should have been conducted to substantiate or dispute the state's theories that the source of these materials was the window screen in the garage, and the window screen was cut as part of the staged crime scene. The apparent wood fragments and blue fibers removed from the knife found on the kitchen counter should have been microscopically examined to determine their source. DNA testing should have been performed on the bloodstains found on the Hoover vacuum cleaner to determine the identity of the person or persons whose blood was on the vacuum cleaner. DNA and possible chemical testing of bloodstains and prints left on the carpet and flooring should have been pursued to determine the identity of those who bled or left prints. Genetic testing should have been conducted on several blood-stained areas of Darin Routier's blue jeans, since they might have indicated that he was involved in the murder. Genetic testing should have been conducted on several blood-stained areas on the furniture, pillow, and wine rack to reconstruct the location and movement of individuals at the crime scene. It is my professional opinion that further testing and evaluation of the items referenced above in numbered paragraphs 6 to 11 would help establish if, in fact, the crime scene was or was not staged. Such testing is necessary to confirm or refute the state's testimonial evidence presented at Darlie Routier's trial and to establish Darlie Lynn Routier's innocence. For example, DNA testing and or microscopic examination should be conducted on bloodstains left on Darlie Routier's nightshirt, the Hoover vacuum cleaner, furniture items, pillow, wine rack, and all flooring and carpeting samples in the state's custody. Chemical testing of the flooring and carpeting samples should also be explored. In addition, all microscopic slides of fibers and other matter removed from 5801 Eagle Drive should be examined to determine their source and or to rule out possible sources. Testing of the brush and powder used to dust the knives in the home at 5801 Eagle Drive should be performed and may refute the theory that fiberglass was consistent with the material from the garage window screen. In order to conduct such testing, access to the above referenced items in the state's custody, as well as samples of the garage window screen and all known blood samples, would be required. Although certain testing might use up a portion of the existing sample, none would destroy the sample completely. Thus, there would be remaining sample for the state to conduct confirmatory testing should it desire to do so. Contrary to the state's theory that a wine glass had been removed from the wine rack and thrown onto the floor to make it appear as if a struggle had occurred as part of a staged crime scene, Labor and Epstein concluded that, quote, the placement of shards of glass below the location of the wine glasses indicated that the wine glass had broken while still in the rack and was not consistent with a person smashing or throwing the glass to the floor, unquote. Contrary to testimony by Lynch that hair found in the torn garage window screen was, quote unquote, microscopically identical to Miss Routier's hair, DNA testing had ultimately determined that the hair found in the screen belonged to police officer Sarah Jones, and they refer to Charles Lynch's testimony, which said, question, and so what that shows is that your microscopic evaluation, although done with the highest technology and with the greatest expertise, later proved, or it was later proved, that that head hair was not in fact Darlie Routier's. Answer, that's right. Contrary to testimony by Lynch that, quote unquote, 4 defects in the right shoulder of Miss Routier's nightshirt were, quote unquote, hesitation punctures that Miss Routier made when she inflicted her own neck injuries, Labor would have testified that the location of these cuts meant that they could not have been made by Miss Routier. Contrary to Cron's testimony that a bloody fingerprint leading out of the living room belonged to a child, trial counsel could have presented testimony that the fingerprint could not have belonged to a child. Yet, significantly, none of this evidence was in fact presented, let alone investigated. B. Legal basis for the claim. Defense counsel has, quote, a duty to garner the expertise necessary to cross-examine the state's expert, unquote, including the duty of investigation. Where counsel chooses to forego his duty to investigate, the Supreme Court has stated, such a choice is, quote unquote, reasonable only, quote, to the extent that reasonable professional judgments support the limitations on investigations, unquote. Quote, in other words, unquote, the court clarified, quote, counsel has a duty to make reasonable investigations or to make a reasonable decision that makes particular investigations unnecessary, unquote. Similarly, a decision to forego the presentation of expert testimony is, quote unquote, reasonable only where an, quote, investigation leading up to the decision not to call the expert witness was itself reasonable, unquote. Where scientific testing is required to determine the viability of a defense and defense counsel has failed to undertake that testing, courts have held that, quote, an actual failure to investigate cannot be excused by a hypothetical decision not to use its unknown results, unquote. Defense counsel Mulder's failure to investigate and rebut the state's staging evidence constituted ineffective assistance of counsel. This evidence was key to the prosecution. If disproven, Ms. Routier could not have been the murderer. Mulder's predecessor had retained defense experts who had identified numerous pieces of physical evidence that contradicted the state's theory of the crime scene. Yet Mulder, after being briefed by one of the experts for only 2 hours, clearly not quote-unquote reasonable investigation, failed altogether to 1. Retain or present the testimony of the existing or any forensic experts, 2. Undertake or facilitate the testing of any physical evidence, and 3. Otherwise rebut the state's scientific evidence before the jury. Through his inaction, Mulder abdicated his, quote, function to make the adversarial testing process work, unquote. This plainly violated Ms. Routier's Sixth Amendment right to counsel. Ms. Routier was prejudiced by Mulder's failure to investigate and rebut the state's staging evidence. The only explanation of physical evidence presented to the jury was the state's. Accordingly, the jury had no option but to accept the state's flawed analysis, as even the state's expert has acknowledged. Quote, further forensic testing on this evidence would have been appropriate in order to adequately investigate the factual basis of the prosecution's theories. Specifically, it is my professional opinion that if Bart Epstein and Terry Labor were released from their retention as expert witnesses for Darlie Routier's defense, such release constituted a grave error on the part of Darlie Routier's defense counsel. Mulder's release of Labor and Epstein and failure to consult any other expert in their place, quote, undermined confidence in the outcome, unquote, thereby prejudicing Ms. Routier. 3. Defense counsel's failure to investigate Darlie Routier's husband constitutes ineffective assistance of counsel. Mulder also failed to investigate numerous leads suggesting that Darin Routier had arranged the June 6, 1996 attack on his residence. Mulder's failure to investigate was unreasonable under Strickland and constituted an independent violation of Ms. Routier's Sixth Amendment right to counsel. Mr. Mulder knew that Darin Routier was possibly involved in the deaths of his sons, yet he did not investigate or present any evidence implicating Mr. Routier. When Mulder took over for Parks and Huff, they specifically advised him of Darin Routier's possible involvement. By letter of October 24, 1996, Douglas Park advised Douglas Mulder of a possible conflict because he concurrently represented Darin Routier. Mr. Parks sent the letter because, quote, Mr. Mulder had suggested that he was not yet fully familiar with all aspects of the case, unquote. Among other things, Parks explained to Mulder that, quote, he continued to believe that Darin Routier was a possible perpetrator of the offense, unquote. Physical evidence available to Mulder further suggested Darin Routier's involvement. For example, the blue jeans that Darin Routier was wearing at the time of the murders contained considerable blood staining consistent with contact-type blood staining. 2 areas on the blue jeans also contained blood spatter, which suggests that Darin Routier was present at the time of the stabbings. In light of this evidence and the information conveyed by Parks, reasonable defense counsel at least would have investigated, if not pursued, a defense strategy that implicated Darin Routier or someone known to him. Mulder did not do either. Had Mulder investigated Darin Routier, he would have learned significant facts helpful to Ms. Routier's defense. Undersigned counsel has learned through simple investigation, for example, that in the spring of 1996, Darin Routier was contemplating an insurance scam that involved staging a burglary of his residence. Darin Routier asked Ms. Routier's stepfather whether he, quote, knew anyone who would agree to burglarize his home as part of an insurance scam, unquote. Mr. Routier explained that, quote, he and his family would be gone from the house and that the burglar would come to the house with a U-Haul truck and remove gobs of stuff from the house, which he would retrieve, quote, after his insurance company paid off, unquote. Darin Routier has admitted that he had this conversation with Robbie Kee only days before the attack on his wife and children. Moreover, 2 years prior to that attack, Darin Routier arranged to have his Jaguar, quote unquote, stolen so that he could collect the insurance proceeds. That quote-unquote crime was executed by a person known to Darin Routier. In light of Darin Routier's intention in 1996 to stage a burglary at his house, the mysterious black car that numerous witnesses testified they saw in the neighborhood around the time of the attacks at the Routier's home constituted additional exculpatory evidence. The same is true of the Rowlett woman who, quote, after 2:00 a.m. on June 6, 1996, unquote, observed two suspicious men, one of whom fit Miss Routier's description of her assailant, walking along a stretch of Darlock Road that was approximately a 10-minute walk from the Routier's home. But none of this information was presented to the jury because Mulder failed to pursue a line of investigation to uncover such evidence. The above facts are more than sufficient to establish that Ms. Routier was denied effective assistance of counsel for defense counsel's failure to investigate Darin Routier. In turn, no evidence implicating Darin Routier or his associates was presented to the jury. Mulder's failure to do so clearly prejudiced Ms. Routier and necessarily undermines confidence in the jury's verdict. Number 4, trial counsel's failure to object to character assassination and use of inadmissible expert testimony constitutes ineffective assistance of counsel. In Section VB, Infra, this petition contends that Darlie Routier was denied her due process rights under the 14th Amendment because of the state's use of character evidence and the use of the inadmissible quote-unquote expert testimony of medical personnel and crime scene technicians. While defense counsel failed to object to the admission of some of this evidence at trial, the record will show that such claims are not procedurally barred because the state habeas court reached the merits of all of these claims without regard to any failure to object. Nevertheless, to the extent that this court should find such claims to be procedurally barred because of trial counsel's failure to object, we contend in the alternative that such failure constitutes a violation of Ms. Routier's Sixth Amendment right to effective assistance of counsel. B. The Routier trial was so infected with unfairness that Ms. Routier was denied her 14th Amendment rights to due process. 1. Relevant facts. A. The state's tactic of character assassination inflamed the passions of the jury and unfairly prejudiced Ms. Routier. As detailed in the Statement of Facts, the trial record is replete with examples of character assassination. From its opening statement, the state made clear its intention to improperly ground its case on, quote, character conformity, unquote, attacks by stating that, quote, the real Darlie Routier, unquote, was, quote, a self-centered woman, a materialistic woman, and a woman cold enough, in fact, to murder her two own children, unquote. And the state continued its assault on Darlie by parading a host of witnesses who did not approve of the way that Darlie dealt with the horrible loss of her children, as if there was a quote-unquote right way to grieve the loss of two young boys. Perhaps the most inflammatory piece of evidence introduced at Ms. Routier's trial was a videotape of a local news broadcast at the graveside birthday party that occurred on June 14, 1996, what would have been Devin Routier's 7th birthday. In the videotape, Ms. Routier is shown singing Happy Birthday, shooting silly string, chewing gum, and laughing. The state claimed that it introduced the tape to, quote, give insight into this woman. In fact, the portions of the video presented to the jury were out of context. The full videotape, filmed secretly by the Rowlett Police Department on June 14, 1996, showed a solemn prayer service held earlier in the day and attended by Darlie and her family. More importantly, it showed that Darlie's family, not Darlie, orchestrated the birthday celebration and brought the party favors and balloons to the gravesite. The secret police surveillance tape also shows Ms. Routier as just one of many people engaging in various activities at the gravesite. That included not only a very brief birthday celebration with children, family, and friends present, but also mourning and remembering the children. The rough timeline for the events on the video, as shown on the video timer rather than the actual time, is as follows. Point 1. Family members decorate the gravesite, and Miss Routier's sister speaks to Devin's and Damon's graves, telling them that she bought silly string and snaps for them. And this is at the 8-minute mark. Gathering for a prayer service. at the 22-minute mark. Prayer service followed by lengthy and quiet gathering of family and friends at 34 minutes. More family and friends begin to arrive at gathering for birthday party. This is at 1 hour and 41 minutes. The birthday celebration was at 2 hours and 3 minutes. The news interview begins at 2 hours and 4 minutes. News interview ends. The Routiers, friends, and family remain at the site discussing various matters, including reminiscing about the Routier children. This is at 2 hours and 30 minutes. A person who appears to be Miss Routier's sister states that she obtained silly string and poppers for the boys, and this is at the 3 hour and 52-minute mark. The jury was left with only one possible conclusion, that the vignettes of Miss Routier shown in the news videotape selected by the state represented how she mourned her children. That type of character assassination was patently unfair to Miss Routier. B. Repeated use of inadmissible medical quote-unquote expert testimony substantially prejudiced Miss Routier. The state introduced inadmissible expert testimony regarding Darlie's state of mind after the murders. This testimony came from medical support personnel who were not qualified to render such opinions and who spent very short periods of time observing Darlie in the hospital recovering from her wounds. None of these witnesses were proffered as an expert trained in judging the response of others to tragic circumstances. None knew Miss Routier's ordinary demeanor or how she normally reacts to trauma, and none claimed to have treated other mothers who were injured at the same time their children were murdered. Indeed, none would have been qualified as an expert under Daubert versus Merrill Dow Pharmaceuticals. And then they state a case number. The prosecution's use of this testimony was intended to show that because she did not act in a hysterical manner, Miss Routier must have killed her children, a point the prosecutor would ultimately drive home to the jury in closing argument. The medical support personnel testified as follows. Santos, one of the attending physicians, was permitted to testify that, quote, most of the time mothers, unquote, when they are made aware or told that a child has died, quote, get hysterical, unquote. He further testified that, quote, they cry, unquote, and, quote, usually tell me I am wrong, unquote. He testified that there is a lot of anger and a lot of pain. He said that as far as all the mothers he had ever dealt with in the same situation, he had not seen anyone react with a flat affect as Miss Routier did. Jody Cotner, a nurse supervisor, was permitted to testify that Miss Routier was kind of withdrawn and didn't cry very often, that she wasn't very emotional, and that this was not the emotions that you usually see with a mother. Denise Falk, a nurse who had attended to Miss Routier on the night of the 7th of June, was allowed to testify that she had dealt with people before that have lost loved ones or close relatives. In response to the question, did Darlie Routier's reaction differ from what you had seen in your experience? She was allowed to opine that it was different in that she didn't portray those characteristics. As a result of the unobjected to admission of this damaging and irrelevant testimony, the prosecutor was allowed to argue, quote, you remember Dr. Santos told you that, of course, he checked on her. He deals with this situation all the time. People that have been seriously injured, people that lose their relatives. I mean, that is part of his job. He said he was expecting her to go crazy. Mothers, many times, when they lose their children, they don't accept that fact. They want to know where they are. They won't accept it when you tell them they are dead. But not this woman. She wasn't of the demeanor he thought she would be. Flat affect is what he called it. Flat affect. Jody Cotner, who is the trauma coordinator. She had been there 11 years. One of her jobs is to work with people to inform people that their loved one has died. She has had to do that hundreds of times. She has had to deal with mothers that lose their children. And what did she tell you? There is nothing like it. The bond between a mother and a child, a grief that is inconsolable. They do it in different ways, but they all show it. And she never saw that reaction from this woman. Never saw the reaction she has always seen before. The same with the other nurses who deal with this stuff every day. They have never seen a reaction like that. It was more of a whining, no real tears. I think you all know what they are talking about now that all of the evidence is in. C. Repeated use of inadmissible quote-unquote expert testimony on crime scene analysis substantially prejudiced Ms. Routier. A significant part of the prosecution's case consisted of quote-unquote expert testimony on crime scene analysis that should have been rejected on the grounds that it failed to meet the Daubert test for expert testimony. These opinions were supported by no empirical studies, were unverifiable, and were based on a methodology that was incapable of being challenged because the testimony was based purely on his subjective instincts. Former police officer James Cron, for example, was permitted to testify as follows concerning his quote-unquote big picture impression of the crime scene. After a 25 to 30-minute initial walkthrough of the crime scene, Cron had formed a belief that there had not been an intruder entry through the window. When asked by the prosecutor why he formed this opinion after his initial walkthrough, Cron said only that it's sort of a big picture. It's not any one thing. It was the overall scene, which primarily is the lack of evidence in many cases. But the entire scene indicated to me that there had not been an intruder. There wasn't any one object or any one situation there. When Cron was asked to summarize the factors he used in reaching this opinion, his testimony revealed that what he had testified to was not fit for expert testimony because, in his own words, this is all common sense. Cron was also allowed to provide his subjective opinion that a glass from the wine rack in the Routier kitchen that was broken at the crime scene was not dislodged by an intruder, but instead that, quote, it looked to me like it had been broken there to simulate or stage an offense. A member of the household broke it and planted it there. Finally, Cron was allowed to summarize his opinion as follows. In my opinion, no intruder committed these offenses. The subjective opinion of FBI Special Agent Alan Brantley was also admitted without a Daubert hearing. Indeed, the court amazingly and incorrectly held that Daubert, quote, has no bearing on a criminal case, unquote. Brantley offered his opinion that, quote, in this particular case, in this particular crime scene, that this crime scene had been staged. And in all likelihood, whoever killed both Devin and Damon was someone that they knew and someone that they knew very well, unquote. It is highly unlikely that such testimony would have passed a Daubert test had the court correctly understood that it applied. Agent Brantley himself noted that his analysis consists of, quote, being aware of the obvious, unquote. That, quote, it takes no behavioral scientist or no rocket scientist to come in here and talk about these kinds of things, unquote. And that it is nothing more than noting the characteristics of the victim, reading the police reports and evidence from the crime scene, and drawing logical conclusions from that information. 2. Legal basis for the claim. Errors in the management of a state criminal trial will result in a denial of due process where, quote, they are so harmful to the cause of truth that, singly or cumulatively, they make the defendant's conviction fundamentally unfair, unquote. The prosecutor's theory of the case that Ms. Routier was cold and materialistic enough to murder her own children was a direct assault on the, quote, fundamental rule of evidence that a defendant's bad character cannot be used to argue that the defendant committed the crime for which he is being tried or had the propensity to commit that crime. Here, this error was compounded by the introduction of quote-unquote expert opinion that is nothing more than subjective opinion. Number 3, Ms. Routier was deprived of a fair trial. Almost all of the state's evidence falls into one of these 3 impermissible categories. 1, the character assassination of Darlie Routier. 2, so-called expert testimony about Darlie's demeanor after the murders. And 3, purportedly expert testimony that was introduced to demonstrate that the crime scene was quote-unquote staged. If all of the evidence falling into these 3 categories had been excluded, as it should have been, the state would have been unable to survive a motion for a directed verdict. The remaining evidence would have shown that Darlie herself had been severely wounded, that her home had been left in disarray, and that an attacker left a bloody sock in an alley far from the site of the attacks. These errors caused Ms. Routier's conviction, depriving Darlie Routier of her right to due process. C. the cumulative impact of the ineffective assistance of counsel and the fundamental unfairness of the trial violated Ms. Routier's due process rights. As set forth in detail above, Ms. Routier's conviction was the product of irrelevant and inflammatory evidence. The majority of the evidence that was presented, or presented and not rebutted, was the result of either the constitutionally deficient performance of Ms. Routier's trial counsel or impermissible character evidence and quote-unquote expert testimony proffered by the state. Taken as a whole, these errors so infected Ms. Routier's trial as to undermine all confidence in the verdict. 1. Relevant facts. The state's case against Ms. Routier was entirely circumstantial. The only true evidence against her consisted of the following. Ms. Routier, although herself attacked, was in the room at the time of her boys' murders. The remainder of the state's case consisted of a combination of improper character attacks and questionable physical evidence designed to demonstrate Ms. Routier staged the crime scene and murdered her own sons. As discussed in Section VB Supra, Ms. Routier's trial was infected with the following due process violations. 1. The state repeatedly presented evidence of Ms. Routier's bad character to show she had the propensity to commit the crime. 2. The state proffered testimony of multiple medical support personnel who offered improper expert conclusions regarding Ms. Routier's state of mind after the murders. 3. The state introduced quote-unquote expert testimony on crime scene analysis that should have been and was not stricken on Daubert grounds. 4. The due process violations that ran throughout Ms. Routier's trial were compounded by the ineffectiveness of her trial counsel, who not only failed to present rebuttal witnesses to contradict the state's theory of a staged crime scene, but dismissed 2 experts who could do so. Trial counsel's conflict of interest also prevented him from introducing a plausible version of the attack, that Ms. Routier's husband was implicated in the crime. Taken separately, these errors are constitutional violations worthy of habeas relief. Taken together, there can be absolutely no confidence in the verdict rendered against Ms. Routier. Number 2, legal basis for the claim. Federal habeas corpus relief may be granted for cumulative errors in the conduct of a state trial, where those errors, quote, so infected the entire trial that the resulting conviction violates due process. When considering claims of cumulative error, the reviewing court, quote, must review the record as a whole to determine whether the errors more likely than not caused a suspect verdict, unquote. Here, the jury's verdict against Ms. Routier was the result of prejudicial evidence of marginal, if any, value that infected Ms. Routier's entire trial. The deficient performance of Ms. Routier's trial counsel, as well as the numerous incidents of abusive character evidence and the questionable expert testimony introduced by the state, constitute independent constitutional errors that infected Ms. Routier's trial. Taken as a whole, these errors so infected Ms. Routier's trial as to constitute a violation of her right to due process. D. Darlie Routier is innocent of the crime for which she was convicted. 1. Ms. Routier has introduced evidence of actual innocence that exceeds the gateway standard under Schlupp versus Dello and is therefore entitled to relief for the specific constitutional violations in her case. Ms. Routier has already introduced significant post-trial evidence of her actual innocence. 1. A bloody fingerprint left on Ms. Routier's glass sofa table the night of the murders has been conclusively determined not to belong to anyone in the Routier household. The state's witness testified at trial that the print was consistent with having been left by a 5 or 6-year-old child. The state's post-conviction fingerprint expert concluded, however, that he was able to exclude all possible known sources of this print, except Ms. Routier herself. 2 separate fingerprint experts have definitively excluded Ms. Routier as the source of this print. 2. Ms. Routier has also been excluded as the source of a bloody fingerprint left on her utility room door, the same door through which she claims her attacker fled. This fingerprint was not introduced at trial. 3. Evidence introduced by the state at trial to show Ms. Routier staged the crime scene, including blood spatter stains on Ms. Routier's nightshirt, blood stains left by a vacuum cleaner, a broken wine glass and fibers found in a kitchen knife has been shown to be mistaken, scientifically false, or otherwise insupportable by forensic scientists Terry Labor and Barton Epstein. Labor and Epstein were retained by Ms. Routier's court-appointed counsel and dismissed by her trial counsel, Doug Mulder. Consequently, Labor and Epstein were not able to complete their analysis, and none of their preliminary conclusions disproving the state's case were introduced at trial. Labor and Epstein have been re-engaged in Ms. Routier's defense and, after further analysis, have substantiated their initial conclusion that the crime scene was not staged. The scientific and physical evidence that has surfaced since Ms. Routier's trial seriously undermines the credibility of her conviction. Moreover, this evidence has been gathered without any access to forensic or biological evidence in the state's possession, without access to the state's notes underlying pretrial DNA testing, and in the absence of any factual discovery or evidentiary hearings at the state level. Evidence of Ms. Routier's innocence will only grow stronger as she is permitted discovery and further investigation in light of discovery in these federal proceedings. When a constitutional error, here Ms. Routier's denial of her Sixth Amendment right to effective assistance of counsel and her 14th Amendment right to due process, results in the conviction of one who is actually innocent, that conviction is not entitled to the same degree of respect as a conviction that is the product of an error-free trial. To establish that a constitutional violation has probably resulted in the conviction of an innocent person, Ms. Routier must show that, quote, it is more likely than not that no reasonable juror would have convicted her in light of the new evidence, unquote. Ms. Routier's conviction differs from a case like Herrera versus Collins, where the petitioner's conviction is presumed to be free of constitutional error. Because an error-free trial necessarily instills more confidence in the verdict, petitioners with Herrera-type claims must meet a higher standard of review. And then it goes on to quote a court case that supports their argument here. It then goes on to point number 2, which says the Supreme Court's pending review of House versus Bell may afford Ms. Routier with a freestanding claim of actual innocence. And then they go on to talk about this other court case, a Supreme Court case, in this point number 2, in order to support their argument for Darlie. And then it goes on to number 6, issues under 28 U.S.C., and then it gives a few numbers, with respect to the state court's findings of fact and adjudication of the claims. And then it goes on. Under 28 U.S.C., a federal habeas court must presume state court findings of fact to be correct and defer to state court determinations of claims unless the findings of fact can be rebutted by clear and convincing evidence, and the determinations can be shown to be objectively unreasonable or based upon an unreasonable determination of the facts in light of the evidence presented in the state court proceedings. In the briefing that Ms. Routier will submit in the course of this litigation, she will demonstrate that the state court findings of facts with respect to all the claims presented herein can be rebutted by clear and convincing evidence. Ms. Routier will also demonstrate that the state court determinations of the claims presented herein are objectively unreasonable or based upon an unreasonable determination of the facts in light of the evidence presented in state court proceedings. In addition, Ms. Routier will demonstrate a more profound procedural problem with the state court proceedings, the abdication of the judicial function by the state habeas judge to the prosecutor. The state habeas judge performed no function independent of the prosecutor. He had reached no decision before asking the parties to draft findings of fact and conclusions of law. He never held a hearing where he played an active and inquiring role. He never provided guidance as to the results and points he wanted addressed in the final order, and he adopted without any material or substantive alteration the state's proposed findings and conclusions. This process deprived Ms. Routier of one of the cornerstones of due process, a fair resolution of the issues in her case by an impartial decision-maker. Ms. Routier's decision-maker was, in effect, her adversary, the district attorney. As such, nothing decided by the state habeas court can be given deference in this court. To do so would be to inflict anew the due process violation already suffered by Ms. Routier. And then it moves on to point 7, which is the prayer for relief. And it states all of the things that they would like to have happen in submitting this document. And it says, wherefore, Darlie Routier prays that this court, A, order respondent to provide this court with the record of all state court proceedings, B, issue a writ of habeas corpus to have her brought before it, to the end that she may be discharged from her unconstitutional confinement and restraint, and / or relieved of her unconstitutional sentence of death. C, grant an evidentiary hearing so that she may present evidence in support of these claims, and D, grant such other relief as law and justice require. And this is dated November 29th, 2005 by Richard Burr. And that is actually the end of the writ of habeas corpus. Now, I had mentioned in the last episode about talking about or reading the different affidavits that were, I think, attached to this particular writ, and they only mentioned a few of them throughout the actual writ document itself, but there are actually quite a few affidavits. And let's begin with the first one is the affidavit of Charles Samford. Now, Samford, he was actually on the jury who had made the decision to convict Darlie. And in 2002, he provided an affidavit, and I will read that to you now. So this is the affidavit of Charles Samford. And most of these are they're very short. They're usually just one page long. But anyhow, let me continue. The affidavit of Charles Samford. From January 6th, 1997 through February 4th, 1997, I served as a member of the jury in the case of Texas versus Routier in Kerr County, in which Darlie Routier was alleged to have committed the murder of her son, Darin Routier. During the trial of Mrs. Routier, the prosecution introduced a videotape take by a news reporter showing a birthday party at the grave of Mrs. Routier's children sometime after her children had been killed. The tape showed Mrs. Routier smiling, chewing gum, and shooting silly string. During our deliberations, I recall that we watched the videotape about 8 or 9 times, although I wasn't keeping count. The videotape was one of the main reasons I voted to convict Mrs. Routier of murder, because I didn't know what to make of her behavior. After trial, I was shown another videotape that I was told was taken by police at the grave site that same day. This second videotape showed a prayer service that happened before the birthday party. Had we been shown this other tape so that we had been able to see the whole picture of what happened that day, I believe I would not have voted to convict Mrs. Routier. Next is the affidavit of Douglas Crowder, MD, who provided an affidavit for the defense saying that his colleague had indicated to him that he had served as a psychiatric consultant on Darlie's case. I am assistant professor of psychiatry at the University of Texas Southwestern Medical School. I am board certified in general psychiatry with added qualifications in forensic psychiatry. And then he gives his business address and his phone number. And he continues. Over a period of years, I have met with a colleague of mine, Dr. Kenneth DeCleva, to discuss a number of issues of interest in the field of forensic psychiatry. During a lunchtime conversation that took place, to my best recollection, in the summer of 2000, Dr. DeCleva told me that he served as a psychiatric consultant for the state of Texas in the capital case of Texas versus Routier. I understood that Dr. DeCleva's duties as consultant were to advise the prosecution on any psychiatric issues presented by the case, and possibly to serve as an expert witness. Dr. DeCleva informed me that he opined to the prosecutors in that case that, in his professional opinion, Darlie Routier is not likely to constitute a future danger in prison. Dr. DeCleva acknowledged that prosecutors had not asked him to testify about this opinion at any point during the trial of Miss Routier. And it's signed Dr. Douglas Crowder. Next up, we have the affidavit of Susan Simmons. And if you remember, she is the court reporter who was asked to redo the original court reporter's records because they were essentially deemed unusable. Now, her affidavit is very long and just contains a lot of details and information that we already knew about. So I just want to give you what her summary says at the bottom after providing all of the essential details within the entire document. And it says, it is fair to say that the following statements about this case are true. A. I do not have personal knowledge of the accuracy of my record or the integrity of the materials that I used to prepare it because I did not attend the trial or create those materials. B. The original reporter's stenographic notes are untrustworthy without corroboration because the accuracy of her keystroking fell below the minimum acceptable level. C. The original reporter lied to the court to conceal flaws in her record that might have resulted in a new trial. D. The original reporter is not available to answer questions about her work because she exercised her right against self-incrimination. E. The certificate on my record is different than the one that is required by TRAP appendix, and then it says order directing the form of the appellate record in criminal cases, B1Q. And then it moves on to F. I used uncertified audio tapes to make tens of thousands of substantive editorial changes in the record that conflict with the original reporter's stenographic notes. G. I cannot certify 53 pages of the record of an important proceeding that occurred on the morning of October 21st, 1996, because the audio tape of that proceeding was lost or destroyed. H. I cannot certify any of the parenthetical descriptions of nonverbal facts. I cannot determine whether there was a hearing about attorney Doug Mulder's conflict of interest that was not reported in Halsey's steno notes or recorded on the audio tapes that I received. I am unaware of any other Texas case in which a reporter's record was certified under similar circumstances. I do not know of any Texas rule, regulation, or statute that authorizes certification under such circumstances. I am confident that I have prepared a true and correct transcription of the verbal part of the proceedings in this case that were recorded on the audio tapes that I received. The courts will have to decide whether that is sufficient to certify a record under the unique circumstances that I have described. And her affidavit was in July of 2002. Next, we have actually two affidavits also from Stephen Cooper, who was the attorney who handled Darlie's appeal process. And his first affidavit was dated July 12th of 2002. And here is what he had to say. I am the attorney of record for the appellant for Darlie in the case styled Darlie Lynn Routier versus the state of Texas under case number 72795, now pending in the Court of Criminal Appeals. In 1998, the trial court verbally ordered the attorneys for Darlie and the state not to contact or speak with Susan Simmons regarding her work in attempting to prepare a new reporter's record after the inaccuracy of the original reporter's record had become apparent. Subsequent to this order, a series of hearings were conducted in which the trial court also prohibited me from questioning Ms. Simmons directly, but rather I, as well as the state, were limited to submitting in writing proposed questions in which the trial court alone would ask of the witness, Simmons. This order remained in force until June 30th, 2000, when the court authorized the parties to interview Ms. Simmons. Following the filing on March 2nd, 2000 of 1. Defendant appellant's objections to the proposed new reporter's record, and 2. Defendant appellant's request for an evidentiary hearing to resolve all the factual disputes about the reporter's record, an in-chambers off-the-record conference was held on June 23, 2000, with the court, me, and counsel for the state. During this conference, I asked the court for permission to interview Susan Simmons in preparation for an anticipated hearing on appellant's, Darlie's, above pleadings, and the court denied my request. At this conference, the court further directed appellant to submit in writing the questions appellant proposed for Simmons in any further hearings on the attempted reconstruction of the reporter's record in this cause. The court again advised that it would be asking all questions of Simmons rather than the parties at any such hearings. Appellant had already submitted in her pleadings filed March 2nd, 2000, her proposed issues and questions to be answered at any hearing. On June 30th, 2000, I filed a motion to permit appellant to interview Susan Simmons the original of which is attached here too as Exhibit 1. After filing it with the clerk and dropping off a copy with the judge, I drove straight back to my office, and Carrie Young, the judge's chief staff attorney, was calling when I walked in the door. He said the judge was going to grant my motion, but the court wanted me back down to court to withdraw the motion. I went back to the court's chambers and was told I could interview Ms. Simmons. The court then handed me the original file-marked copy to me across his desk and said, "Take this with you." On July 12th, 2000, I went to Tyler, Texas, and along with appellant's Writ Counsel, Stephen Loesch, and another attorney, Eric Albritton, who was assisting Mr. Loesch, interviewed Ms. Simmons. Attached here too, as Exhibit 2 and incorporated by reference, is an affidavit form prepared for Ms. Simmons' signature, a true and accurate summary of Ms. Simmons' statements during the afternoon of July 12th, 2000. Ms. Simmons advised me today that while she is willing to testify in court in this matter, she didn't feel it was appropriate as the court's expert to sign any affidavit without the court's permission. On July 14th, 2000, another in-chambers off-the-record conference was held with the court, me, and counsel for the state. The purpose of this conference was, according to the court, for me to advise the court what Ms. Simmons may have said, which I felt would require a new hearing. I revealed many of the things which she had said, which either conflicted with or clarified some of her prior testimony. After some time, both the court and Lindsay Roberts, assistant district attorney, agreed that a new hearing was necessary to clarify Ms. Simmons' testimony both in this court and before the Court Reporter Certification Board, where Simmons had also testified on the subject of this record. This hearing was eventually scheduled for September 7th, 2000. Sometime after 4 p.m., a member of the news media called me and said he had been told by court personnel that the hearing had been canceled, a fact which I subsequently confirmed with the court administrator. And again, this is on July 12th of 2002. Next, we move on to the second affidavit of Stephen Cooper, and this was also done on July 12th of 2002. And it says, beginning in January 2002, I have made several requests of the court and/or the Dallas County District Attorney's Office for access to evidence in this case, both items admitted into evidence at trial and items which were not placed in evidence. Pursuant to a court order on or about February 21st, 2002, I was granted access to several state's exhibits for the purpose of allowing my forensic expert, Ed Huskey, to visually inspect the items. Thereafter, I was provided by the state with photographs of a pair of bloody blue jeans in the custody of the Rowlett Police Department, but I was denied by the state my request to permit Mr. Huskey to visually inspect the jeans. Following the receipt of Mr. Huskey's preliminary analysis of the items he inspected, together with other materials he reviewed, Mr. Huskey advised of specific scientific examinations or tests he recommended to investigate further potential claims for appellant's writ of habeas corpus. I subsequently spoke to both Libby Lang and John Rollator, assistant district attorneys, and requested they permit these further tests, and my requests were denied. I then filed on May 29, 2002, appellant's, quote, petitioner Darlie Routier's expedited motion for access to state's physical evidence, unquote. Following the court's ruling on this motion, and here it says 8, 2002, I spoke with John Rollator and requested that my expert be permitted to inspect the district clerk's office state's exhibit number 25, appellant's bloody t-shirt. My expert would only use one or more microscopes and possibly photographic equipment without causing any destruction or alteration of the exhibit. I asked that this be done on July 11th, 2002, and again, this request was denied by the state. And again, this is on July 12th of 2002. Next, we have the affidavit of Robert Lohnes, and he was actually a latent print consultant who was obtained by ABC News to examine the bloody fingerprint known as 85-J. And here is what his affidavit says, and this was on January 29th of 2003. And it says, my name is Robert C. Lohnes, and I am fully competent to make this affidavit. I am a latent print consultant, and attached here too as Exhibit A is a current curriculum vitae. In my capacity as a latent print consultant, ABC News employed me to examine several photographs of latent prints identified to me as being from the criminal case against Darlie Routier in Dallas, Texas, including State's Exhibit number 85-J. Applying the accepted standards of fingerprint analysis, I compared the photograph of number 85-J to the print card of the subject Darlie Routier that is attached here too as Exhibit B. It is my opinion that 85-J was not made by the person from whom the fingerprints on Exhibit B were taken. Next, we again have two affidavits and these will be the last for the defense. And these are from Richard Jantz, and he worked with Darlie's appeals attorneys in the capacity of an anthropological analyst. And his first affidavit is done on July 9th of 2002. And this is what he has to say. I am a professor at the University of Tennessee Department of Anthropology in Knoxville, Tennessee. In this capacity, I undertook an anthropological analysis of State's Exhibit 85-J from the case styled The State of Texas versus Darlie Routier to determine, if possible, whether the latent fingerprint reflected in the exhibit was made by an adult or a child. My report of this analysis is attached to this affidavit and incorporated herein. Also attached to this affidavit and incorporated herein is my curriculum vitae. The statements in this affidavit are true and correct. And his affidavit contains quite a bit of detailed information, very technical information. But at the very bottom, it has his conclusion. And it says, the foregoing analysis is able to successfully identify the prints of two known children, the thumb of Damon Routier and digit 4 from Devin Routier as those of children. The latent print consistently has a higher probability of having been made by an adult. The probabilities range from 0.767 to 0.985, depending upon which character is being used. His second affidavit is done on February 26th of 2003, and here is what this one says. I have reviewed the state's response to my previous affidavit filed in this case, and I believe that the state has misunderstood or misrepresented my analysis of the latent print shown in State's Exhibit 85-J in the following respects. The state's claim that my analysis is flawed is unsupported and appears to be based on a misunderstanding of anthropology, dermatoglyphics, and/or probability. Dermatoglyphics is a branch of anthropology, anthropological dermatoglyphics, medical genetics, and genetics. This science is distinct from that used by criminalists when they identify a latent print as that of a particular suspect. The methodology that I used to analyze Exhibit 85-J is commonly used by forensic anthropologists. That methodology uses biological systems that are correlated with chronological age to estimate chronological age. Forensic anthropologists, for example, routinely assess the age of skeletal remains from dental development, bone length, or bone development. My report, therefore, is in line with the standard practice of forensic anthropologists. Although less is known about age changes in length of the terminal phalanx or the breadth of ridges than is known about other age indicators, it is well established in the scientific literature that these ridges grow as a child gets older. The following articles discuss this issue, and then he gives a list of certain articles. Although the fingerprint study I conducted on Exhibit 85-J is not typically used by forensic anthropologists, conceptually, it lends itself to the circumstances of this case where you are trying to determine the characteristics of the source of a latent fingerprint. Specifically, I was tasked with determining the probability that the source of the fingerprint in Exhibit 85-J was an adult male, adult female, or child. The state's claim that my methodology is not accepted by fingerprint examiners is beside the point. Fingerprint examiners use an altogether different method to identify fingerprints. My methodology is accepted by anthropologists. Anthropologists accept that physical characteristics known to change with age can be used to estimate the age of a particular subject. Anthropologists also accept that fingers increase in size with age and that ridges get wider to keep pace with the growing finger. There is some literature on growth in ridge width. The state mistakenly suggests that my analysis, quote, does not account for stretching or compression of the skin, unquote. In my analysis, I measured ridge breadth in the accepted way, and it has never been shown that stretching or compression significantly alters that measure. There are two possible sources of error with my methodology. One, misclassification due to overlapping distributions or different classes of people, males, females, children, and adults. And two, distortion of the actual finger configuration by the latent print. However, neither source of error significantly impacted my conclusion. The first error source is embedded in the posterior probabilities, which show that in general, State's Exhibit 85J cannot be excluded from any class with 100% certainty. The probabilities are reliable guides to likely misclassification and hence constitute an assessment of error. As reflected in my report, the probabilities are between 0.767 and 0.985 that State's Exhibit 85J is the fingerprint of an adult, depending upon which characteristic is being used. The second error source is unknowable, but is unlikely to have played a large role because the results from three entirely different measurements converge onto a common answer. It is unlikely that distortion would have the same effect on these different measurements in the same way. There is also evidence of the unlikelihood of error because the technique was able to correctly classify the two known children whose prints were taken in entirely different ways. Devin's right thumb from a post-mortem photograph and Damon's right fourth from a school print card. Contrary to the state's representation, my report does not identify applicant as the most likely source of the print. My report does not rule in or out any particular adult female or any particular adult male. Pat Wertheim's suggests that my report raises quote-unquote suspicion because probabilities are reported in my analysis as either a percentage or a decimal. They are in fact the same thing. Percent divided by 100 equals decimal. The statements in this affidavit are true and correct and within my personal knowledge. Because this is so long, I'm going to make this recap as brief as I possibly can. And you all know me by now that sometimes when I say that, it means it goes pretty long, but I will do my best to keep it really short. So essentially, there's, at least the way that I viewed it, there was two major pieces that they were trying to hit on within this writ that they have done. And one of them specifically was regarding Darlie's attorney, Douglas Mulder. One of the major issues that people had with him was that, first of all, he had a conflict of interest, or people truly believed that he had a conflict of interest. And if you read through this writ, I can completely understand why they would think this. I am less and less impressed with this attorney the more that I learn about him, especially when we hear the affidavit of Darin Routier, who said, hey, you have to agree to not bring me into this whatsoever. And Mulder agreed. He did after the fact, when it was in closing and there wasn't any, other evidence to show. But we have learned throughout this entire document, especially the affidavits, are so helpful, especially Darlie's original attorney, Douglas Parks, who actually went to Mulder and said, hey, we, based on the information that we're finding so far, we're actually pointing this towards Darin. And his investigators had found some things. They had gone through the evidence and, this Terry Labor and this Bart Epstein, they had done all of this work and on the bloodstains and so forth. And then as soon as Mulder was brought in, he had this really short 2-hour conversation with them. One of them said, I think it was Terry Labor who said in his affidavit that, look, they didn't ask any questions. They didn't really seem interested. And as soon as they left, he really thought that they would hear from him again because they had done all this work up until this point. But remember, they had done all of this work that essentially pointed the finger at Darin. And Mulder has said, hey, I, at least according to Darin, I agreed that I wasn't going to bring him into this. So why use these guys if they're just going to give me information that I can't use anyway? So he essentially, fired these two and never really followed up with any other information or details or evidence that could counter what the state was trying to bring up in their case against Darlie. Not to mention that even though I believe they still had the original full video of the graveside service, where it was the prayer service and everything prior to the birthday party one that the state showed, Mulder decided not to show this. That just, blows my mind that why wouldn't you also show like the whole picture, the entire picture? And then in this writ, of course, it focuses a lot on Darin. Some of it about his behavior, both before and after the crime. We learn about the fact that he had somebody steal his car so that he could collect insurance money. We also find out that he had gone to his father-in-law, or at least, Darlie's stepfather, to ask if there was a way that he could have somebody come into his home and steal his stuff so that he could claim it on insurance. So, insurance fraud. And then we also learn that, him and Darlie, they had a fight the night, or I don't know if you'd call it a fight, but Darlie had evidently asked him for a separation the night before the crimes occurred. Darlie also had more life insurance on her. And to be honest, the entire trial just seems so, I don't know how to phrase it, so odd. But there were so many things that could have been done that weren't done. There was evidence that had been researched that wasn't allowed to be brought into trial, either because of the conflict of interest or some other reason. And Mulder didn't really offer any rebuttal witnesses when the state brought up people to say, hey, here is what we found and this is what we think it is. And, it just really, I don't know if he just went into this thinking, hey, I'm really good at this. And, there's no way, this is all circumstantial, which I do agree with. And that maybe he just felt that, hey, it was a slam dunk case. He didn't really have to, do much. And both Darin and Darlie's mom, Darlie Kee, evidently wanted Mulder to take over the case. I don't know why, but honestly, it kind of makes me wonder. As Darin said, he talked with Mulder. He said, hey, this is okay as long as you don't bring me into this. And Mulder agreed with it. So, but essentially, if you really think about this, he's essentially saying, hey, yeah, go ahead. Throw my wife under the bus. Who cares? Just as long as I don't have to be a part of this. Because honestly, that's the way that I see it, right? I mean, that's really the only way that you can see it. So Mulder instead decides to, we're just going to use this intruder that came into the house. And that is going to be that's our line. And which may actually be the case, right? I mean, there's so many things that were not included. There's so many things that were included. We find out about this fingerprint that wasn't matched to any part of anybody in the family, and that it wasn't even brought up in trial. Why? You would think that this would be a very important piece of evidence, don't you? So again, I'm just going to leave it at that. All I'm doing is just blurting out my thoughts and the things that kind of popped up to me as I'm sitting here and going through this entire writ, especially with all of the affidavits. And that will do it for this episode. In the next episode, it is going to be nothing but the state's affidavits that they have for their side of things. So thank you all for listening. I appreciate you all so very, very much. If you haven't yet, consider subscribing to the podcast, especially if you're on YouTube. Just click the subscribe button. Again, it doesn't cost you a thing. If you want to be notified as soon as new episodes are released, just click the little bell. And if you like this episode, just give it a thumbs up. Thank you all so much. We will talk very, very soon. Bye for now.